I am 14 and I want to live with my dad. My parents have shared custody, but my mom wants to keep me with her, and she's not a good person. How do I stay with my father full time? I will answer this question in the context of Utah law because I am licensed as an attorney and practice divorce and family law in the state of Utah. For the typical child in your situation, i.e. one who wants to obtain a modified order from the court that changes the award of child custody from one parent to another, there is precious little that the child can do to effect this change. In fairness, there are some good policy reasons for why this situation arises. For example, young children may have poor judgment and may not know whether residing primarily with the parent that the child wants to reside with is in the child's best interest. A 9-year-old child may say that he or she wants to live with a particular parent, not because that parent is a fit parent, but just the opposite. For example, that parent may not ensure the child completes homework or chores, or doesn't ensure the child practices good hygiene. The parent may not feed the child well, or just feed the child junk for meals, impose no discipline, etc. A tweenage or teenage child may say that he or she wants to live with a particular parent, not because that parent is a fit parent, but because that parent lets the child run wild, skip school, drink, smoke, take drugs, be sexually active, etc. Many young children can be too easily manipulated and or intimidated into saying that they want what they don't really want by way of the custody and parent time schedule. Some feel that seeking the input of children on the subject of child custody and parent time awards, quote, traumatizes, close quote, the child. Traumatize is a word grossly overused in family law, by the way. People claim that talking to the children places them in a position where they must favor or choose one parent over another. These are clearly factors worth carefully considering if and when a child objects to residing with a particular parent or objects to a particular custody or parent time schedule or seeks a change. But too often, courts invoke these factors as a reason to utterly silence and to completely ignore anything a child has to say on the subject. Why? Is it because all minor children are clearly unable to be taken seriously because of their status as minor children? Obviously not. While some children may be too young or too immature to have sound bases for or to make sound arguments for their custodial preferences, plenty of children are more than sufficiently intelligent and mature and responsible to be credible witnesses on their own behalf. And we'll never know whether a child is a credible or an incredible witness if we don't inquire with the child first. Courts reject the testimony of lying and incompetent witnesses all the time, as well they should. Yet many courts reject a child's testimony without giving the child a chance to speak on the grounds that they might lie, that they might be coached, and or that they might be too stupid or naive to be taken seriously. That's no different than convicting a defendant without a fair trial because he, quote, might be, close quote, guilty. Is it because asking a child to express his or her opinions is inherently and irreparably harmful to all children, or even to most children? Obviously not. If a child tells his or her parents and the court, quote, don't ask me to talk about this, close quote, then it might be that honoring that child's wishes is best. By the same token, however, if a child tells his or her parents and the court something to the effect of, quote, I have a greater stake in the child custody and parent time awards than anyone else involved in this case, close quote, or, quote, I have experiences, observations, opinions, and desires that deserve to be considered before the court makes these decisions that will affect my life for years to come as a youth and throughout my life as an adult, close quote. So why do some, most, though not all, courts refuse to hear from children about their custodial preferences and the reason for those preferences? Why do some courts muzzle the children from the outset? Why do they refuse to weigh the credibility and evidentiary value of what the children who want to be heard have to say? In my opinion, it's laziness disguised as prudence or compassion. So what does a child who wants and deserves a change of custody to do? This may sound radical, but it's really not. And the answer is, get your own attorney to help you. That's the legal way to do it. Unfortunately, it's easier said than done. You'll be excoriated and mocked for trying. You may even be threatened. Be prepared for all of this. There are all kinds of extra-legal self-help methods that are easier and cheap or free by comparison, but that has never been an excuse to break the rules and to lie, unless the rules are inherently fair or administered unfairly, in which case you could argue that you don't have an obligation to obey such rules. I encourage children in your situation to work through the system even when it's organized and administered to work against you.